Welcome back to the deep dive. Today, we're wading into some potentially complex, but utterly essential waters.
hmm
The world of property when it has a connection to more than one country.
hmm
If you've ever wondered what happens legally when you own, say, a holiday home abroad, or inherit assets scattered across borders, or maybe buy goods that have traveled half the world, well, this is the deep dive for you.
Yeah, it really is.
It's all about figuring out which country's laws apply when property gets tangled up in these cross-border situations.
Exactly. And this is the domain of conflict of laws,
Yeah.
sometimes called private international law, specifically as it applies to property.
Right.
It gives us the rules, sort of the navigational chart, for figuring out which legal system governs property rights when there's some kind of foreign element involved.
Yeah, because without those rules, it'd just be chaos.
Absolute legal chaos. They're crucial for certainty, in international deals, personal affairs, everything.
Absolutely. And for this particular deep dive, we've got a very specific map we're following.
We do.
This session is based on educational material made available by the University of London for its students studying this exact area.
That's right.
And we need to be crystal clear. These discussions are strictly for educational purposes. They're designed to help you, the listener, understand the principles laid out in this specific material.
And we also want to say a big thank you because this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
Yes.
They actively support students in tackling challenging subjects just like this one.
Fantastic. So speaking directly to you, our listener, especially if you're digging into this material, maybe prepping for an exam on it,
hmm
we wish you the absolute best of luck, seriously. Our aim here is to really unpack the key concepts, the specific rules, and the crucial cases from these sources.
Yeah, to help consolidate your understanding, make you feel as ready as you can be.
Exactly.
We've got a pretty clear path laid out. We'll kick off with a really fundamental step, how property is actually classified for these conflict purposes because, it's different from standard English domestic law.
Okay, classification first.
Then we'll look at the rules for transferring tangible, movable property, physical stuff.
Right.
After that, we move into the more abstract world of intangible movables, things like debts and shares.
Got it.
We'll explore some specific types, like negotiable instruments and shares, because they have their own quirks.
Okay.
Then tackle the unique issues around immovable property land situated outside England. That covers both jurisdiction, like can an English court even hear the case, and choice of law.
Ah, the Mozambique rule territory.
Exactly. And finally, we'll delve into the rules governing matrimonial property, how marriage affects property rights across borders.
Okay, that is a lot to cover, but it sounds incredibly important, especially now everything's so globalized. Let's unpack this.
Right. So the very, very first step, whenever you're facing a conflict of laws problem involving property, is figuring out what kind of property you're actually dealing with. But, crucially, in conflict of laws terms.
Okay, so not just thinking about it in the way English domestic law does, like real property versus personal property.
Exactly. Put those terms aside for a moment. Choses in possession, choses in action. Pause that thinking. That's not the system used here.
Ah, okay. So the English conflict of laws rules actually use a different framework.
Precisely. For conflict purposes, English law adopts the classification used in many other legal systems, particularly civilian ones. The basic fundamental distinction is between movables and immovables.
Movables versus immovables, simple enough. And I guess movables are then broken down a bit further.
Yes, they are. Into tangible movables, things you can physically touch and move, like, a chair or a book.
Right.
And intangible movables, these are more abstract rights, like debts, shares, intellectual property.
Okay, tangible and intangible movables. That sounds a bit like the English domestic idea of choses in possession and choses in action, but maybe not identical.
It's similar conceptually, yeah, but the terminology and the underlying system are different. Movable, immovable is the key conflict distinction.
Okay, so why? Why adopt this sort of foreign civilian system instead of sticking with the familiar English one? What's the reasoning behind that?
Well, the source material really highlights this. It's about international harmony. This civilian classification, movable, immovable, is much more universal.
Ah, so other countries recognize it more readily?
Exactly. Using it helps ensure that judgments and decisions made in one country can be recognized and enforced in another. If English courts stuck rigidly to their unique real versus personal property thing,
Yeah.
courts in, say, France or Germany, which use the movable system, might classify the exact same piece of property completely differently.
And then you'd get conflicting results. Chaos again.
Precisely. It undermines predictability. Conflict of laws is all about creating predictability and order in cross-border situations. So, adopting this common classification language is a vital step towards that.
That makes a lot of sense. It's about speaking the same legal language, at least for classification, so decisions are respected internationally.
Okay, so the system is movable, immovable, and then tangible, intangible movables. But how do I know for a specific item, say, a piece of machinery on a farm somewhere, whether it counts as movable or immovable in the system? Do we just look at it or use an English
Well,
definition?
no, neither of those, actually. This is the critical principle, the foundational rule you absolutely must remember for classification.
Okay, right.
You determine whether property is movable or immovable by looking to the lex situs.
The lex situs, the law of the place where the property is situated.
Exactly that. You ask the legal system of the country where the property is physically located, how do you classify this thing? Is it movable or immovable according to your law?
So it's not about my English viewpoint, it's about the local law's definition.
Yeah.
Why is that so crucial?
Again, it comes down to practicality and international relations. The source emphasizes this strongly. If you don't classify according to the lex situs,
You'll inevitably reach conclusions that the courts in the country where the property actually is, or other relevant countries, simply won't agree with. They won't enforce your judgment.
I see.
Classification by the lex situs is fundamental because it often dictates which country's law will then govern the really important stuff like how the property can be transferred or who inherits it. It's the gateway step.
Okay, let's make this concrete. The source gives some really good examples. The first one involves someone dying without a will and testate succession.
Right. Let's paint the picture. A dies intestate, no will. A was domiciled in England at the time of death, owned a farm over in Bulgaria, and on that farm, A also owned some farm animals.
Oh, okay. Farm in Bulgaria, animals on the farm, owner domiciled in England.
Now, under English conflict of laws, rules for intestate succession, there's a split. Succession to movables is governed by the law of the deceased's last domicile.
So English law in this case, because A was domiciled in England.
Correct. But succession to immovables is governed by the lex situs.
Which would be Bulgarian law, because the farm is in Bulgaria.
Exactly. The farm itself is clearly an immovable, so Bulgarian law governs who inherits the farm. No question there. But what about the animals?
Ah, are they movable or immovable? That's the question.
Precisely. And how do we answer it?
We look to the lex situs, Bulgarian law.
Yes. So if Bulgarian law classifies those farm animals as movables,
Then their succession is governed by English law, the law of the domicile, because they're movables.
correct. But what if Bulgarian law classifies those same animals as immovables? Maybe because they're considered, I don't know, essential stock of the farm, permanently attached in some legal sense.
Okay, if Bulgarian law says they're immovables.
Then because the lex situs, Bulgarian law, classifies them that way, their succession is governed by Bulgarian law, the lex situs, just like the farm itself.
Wow.
The source mentions an old case, Ex parte Rucker, where slaves in Jamaica were classified as immovable by Jamaican law, the lex situs, even though from an English perspective, they might seem like movable property.
That really drives it home. The classification by the lex situs can completely flip which country's law applies to the actual inheritance.
It's a perfect illustration.
Yeah.
It's not about how we see the property. It's about how the law of its location defines it for these purposes. So that classification step, using the lex situs, is absolutely critical. It directs you to the correct governing law for the substantive issue.
Got it. That's a huge takeaway. Lex situs for classification is step one. Now, what about the second example? Freck v. Lord Carberry. That deals with leasehold land in England, which is tricky because domestically, English law calls it personal property.
Yes, and based on what we just said, personal property sounds like it should be immovable, right?
Exactly. That's the potential trap.
But what's the rule?
Yeah.
Classify by the lex situs.
Okay, so the property is leasehold land in England. The lex situs is English law.
Right. The facts were, a testator domiciled in Ireland left a leasehold house in London. The legal question was whether the validity of this gift in the will should be governed by English law, as the lex situs, or Irish law, as the law of domicile, which would apply if it were treated as a movable.
So we ask English law as the lex situs, how do you classify this leasehold interest for conflict of laws purposes?
Precisely. And English law, when acting as the lexitas for conflict purposes, says that an interest in land, even a leasehold interest, is fundamentally an interest in an immovable.
Ah, okay. So its connection to the land itself trumps the domestic personality label.
Exactly. For conflict purposes, it's treated as relating to an immovable. Therefore, the property was classified as an immovable, and the validity of the gift was governed by English law, the lexitas. As it happened, the gift was invalid under English law.
Wow. So Freak v. Lord Carberry is a key case showing that even domestic personality, if it's fundamentally about land, gets classified as an immovable by the English lexitas rule in conflict of laws, meaning the lexitas governs its disposition.
That's the point perfectly put. It really underscores that conflict classification is separate from domestic labels. And the third example Research told reinforces this with freehold land.
Okay, what happened there?
B died domiciled in Hungary. He owned freehold land in England, but it was held on a trust for sale. Now, under English domestic law rules of equity, land held on trust for sale is treated as if it were already money, i.e. as personality.
So the same potential trap again looks like personality domestically, but it's still land. Is it movable or immovable for conflict purposes?
Now, the process is identical.
Yeah.
First, classified by the lex situs. The land is in England, so English law is the lex situs.
Right.
And English law, as the lex situs, regards freehold land as an immovable, full stop. So B's interest was classified as an interest in an immovable.
Meaning English law governed its disposition.
Yes. Only after establishing that English law governed did the domestic distinction between realty and personality become relevant, and that was only to figure out which specific English rules applied to determine who was entitled under the will or intestacy.
So Freak and Research told together are really powerful examples. They hammer home that English lex situs classifies land-related interests, even leaseholds or land on trust for sale, called personality at home, as immovables for conflict of laws, and therefore the lex situs governs them.
Absolutely. The fundamental nature of the asset as land is decisive for its immovable classification in conflict of laws.
Yeah.
Now, just briefly, the other distinction, tangible versus intangible movables. This one is actually quite close to the English domestic distinction between choses in possession and choses in action.
Okay, so tangibles are physical things, paintings, jewelry, cars.
Things of physical existence, yes.
Right.
And intangibles are abstract rights, shares in company, patents, copyrights, debts owed to you, trademarks, no real physical existence in themselves.
Right.
The source does flag one potential complexity here, though. Sometimes title to an intangible right, like shares, is represented by a tangible document, like a share certificate.
Ah, so which is it? Are you dealing with a piece of paper or the underlying right?
Exactly. It can raise questions about whether the issue is about entitlement to the physical certificate itself or entitlement to the shares as an intangible right. We'll see this tension pop up again when we discuss shares specifically later on.
Okay, got it. So the big takeaway from this whole first section on classification is, step one, forget English domestic labels like real personal. Think movable, immovable. Step two, and this is non-negotiable, classify the property by applying lex situs, the law of where the property is located. Cases like XP Rucker showing how classification changes the outcome, and Freak v. Lord Carberry and Research told showing land is always immovable via lex situs are crucial illustrations.
That's a perfect summary of the crucial first step. So now that we know how to classify property for conflict purposes, let's move on to the rules that govern the actual transfer of ownership. We'll start with the most straightforward category. Tangible, movable property. The physical stuff.
Okay, so we have a tangible, movable, a car, a piece of art, machinery, and someone is transferring ownership. Selling it, giving it away, maybe even pledging it as security. Which country's law decides if that transfer actually worked, if the ownership effectively passed?
Well, historically, the source points out, there wasn't always complete agreement. People argued for different rules.
Like what?
Some suggested the law of the party's domicile, but that's messy if they have different domiciles.
Right.
Others proposed the lex loci actus, the law of the place where the transaction physically happened, like where the contract was signed. But as the source notes, that rule has fallen out of favor even for contracts generally, so why use it specifically for property transfer?
Okay. Any others?
The lex actus, or the proper law of the transaction, was another idea. But that doesn't really work if there is no transaction, like if the property is stolen or if there are multiple transactions happening in different places.
So that leaves the lex situs, the law of the place where the property is physically located at the time of the transfer. The source seemed keen on this one earlier for classification.
And it's absolutely dominant here, too, for the transfer itself. The source states it very clearly. The lex situs is the general rule governing the transfer of tangible movables. It's simple, it's certain mostly, except maybe for goods that are literally moving at the time, goods in transit.
And there's case law backing this up.
Strong case law. The source quotes Devlin J. in Bank, Voorhandel in Scheepvaart, NVV Slatford, saying there's little doubt that it is the lex situs which, as a general rule, governs the transfer of movables when effected contractually. Cases like Ray Anziani and Hardwick Game Farm also point this way.
Okay, so if I sell my painting while it's hanging in my London flat, English law determines if the buyer gets good title.
Exactly. If the property stays put in one country during the transfer, that country's law governs whether title passes. The source gives the example from Inglis v. Robertson. If you're in England and you make an agreement to pledge goods as security, but those goods are physically located in Scotland,
Then Scottish law, the lex situs of the goods, decides if that pledge is valid and creates a security interest.
precisely, even if the agreement was made elsewhere.
Okay, that seems fairly straightforward when the property stays still. But the interesting bit is when things move. What happens if property is transferred in country A, according to country A's law, and then it gets moved to country B, where the law is different? This is where those famous cases come in, right? Kimmel v. Sewell.
Yes, exactly. This is where the principle really gets tested. Kimmel v. Sewell is the classic case. It involved a shipment of timber going from Russia to England. The ship got wrecked off the coast of Norway. While the timber was sitting there in Norway, the ship's master sold it to the defendant. Now, under Norwegian law at the time, this sale did give good title to the buyer, the defendant, even though the master probably didn't have the proper authority from the original owners. Under English law, that sale likely would not have passed good title.
Right, the nemo dat rule, generally in English law, you can't give what you don't have.
Exactly. But the sale happened in Norway, under Norwegian law. Later, the timber was brought into England. The original owners, the plaintiffs, saw it and claimed it back, saying, "That's our timber. The sale in Norway wasn't valid by English standards."
And what did the English court decide?
The court held that the title the defendant acquired while the timber was in Norway under Norwegian law, the lex situs at the time of the sale, was a valid title and would be recognized in England, even though English law wouldn't have reached the same result if the sale happened here.
So the title acquired under the lex situs stuck, even after the goods moved to England.
Yes. Kimmel v. Sewell establishes a really fundamental principle. If a transfer of tangible movables is valid, according to the lex situs, at the time the transfer takes place, that title will generally be recognized as valid in England, even if English domestic law would have produced a different outcome, and even if the property subsequently comes to England.
That feels like a very strong rule, potentially quite tough on the original owner who lost their goods. What's the justification for giving the lex situs such power?
Commercial certainty. That's the driving force, according to the source. Think about it. If you buy goods in good faith in France and you get good title, according to French law, lex situs, imagine the chaos if that title could suddenly be challenged just because you later ship the goods to England where the rules might be different.
Yeah, international trade would grind to a halt.
Exactly. The law prioritizes protecting bona fide purchasers who rely on the law of the place where they acquired the goods. It values the security and finality of transactions that happen where the goods are located.
Okay, that makes commercial sense. The second big case illustrating this principle is Winkworth v. Christie, Manson and Woods, Ltd. This one involves stolen art, right?
Yes, another classic. Artworks were stolen in England. They were then taken to Italy. While in Italy, they were sold to someone, D2, who bought them in good faith, apparently unaware they were stolen.
Okay.
Now, under Italian law, the lex situs, at the time of the sale, it was possible for a good faith purchaser to acquire good title, even to stolen goods. That's different from English law, where the thief generally cannot pass good title.
Right, the nemo dat rule again?
So D2 bought the art in Italy, getting good title under Italian law. Later, the art was brought back to England to be auctioned by Christie's, D1. The original owner, the plaintiff, spotted them and sued to get them back.
And following the precedent of Kimmel v. Sewell?
The court applied Italian law as the lex situs at the time of the sale and delivery in Italy.
Which meant D2, the good faith buyer in Italy, had acquired valid title.
Correct. And that valid Italian title was recognized in England. The original owner couldn't get the art back. Slade J. in Winkworth explicitly followed Kimmel v. Sewell. He acknowledged the result might seem harsh on the original English owner.
Yeah, you could say that.
But he argued the opposite result would be equally unfair to the innocent Italian purchaser who had relied on the law of the place where they bought the goods, the lex situs. So Winkworth powerfully reaffirms the principle. The law of the place where the transaction and delivery happen and where the goods are located at that time is paramount for determining whether title passed at that specific point.
So the big lesson from both Camel v. Sewell and Winkworth is, for tangible movables, title validly acquired under the lex situs at the time of the transaction is incredibly powerful. It's generally recognized in England even if the property moves, largely because of the overwhelming need for commercial certainty in international dealings.
That's absolutely the core principle. The lex situs governs the transfer. But, as with most legal rules, are there any exceptions? Can this powerful lex situs rule ever be overridden?
The source does mention a few potential exceptions, though they seem quite narrow in practice.
Yes, very limited. First off, public policy. An English court could, in theory, refuse to recognize a title acquired under a foreign lex situs if applying that foreign law, or the way title was acquired under it, is considered profoundly contrary to fundamental English public policy.
So not just different, but really offensive to English justice.
Exactly. The source suggests it would need to be particularly outrageous. Think maybe Nazi expropriation laws during wartime, that kind of thing. Not just a rule about good faith purchase that happens to differ from England's. It's a very high bar.
Okay, public policy is rare.
Yeah.
What else?
Well, Slade J. and Winkworth suggested, just as an aside, an obiter dictum, that maybe the lex situs rule shouldn't apply if the person acquiring the title under the foreign law lacked good faith.
So questioning the bona fides of the buyer.
Yes, but the source rightly questions this suggestion. It points out that even under English domestic law, like the Sale of Goods Act 1979, sometimes a buyer who isn't acting in perfect good faith can still acquire good title. For instance, buying from someone whose own title was only voidable.
Right.
So it would seem a bit inconsistent to impose a stricter good faith requirement when evaluating the effect of a foreign lex situs than we sometimes apply under our own law.
Good point. Seems like a weak exception then. Any others?
A practical one. Goods in transit. If the goods are literally moving on a ship on the high seas, perhaps, and their situs is just casual or unknown at the exact moment a transaction regarding them takes place, then a transfer that's valid by the proper law of that transaction might be recognized as effective in England.
That makes sense. The lex situs rule doesn't work well if you can't pin down the situs. What about an English statute? Could Parliament override this common law rule?
In theory, yes. Parliament could pass a mandatory statute saying that for certain types of property or transactions, English law must apply regardless of the situs. But the source states there's probably no such statute that generally overrides the common law lex situs rule for tangible movables in this way.
Okay. And finally, the source discussed Glencore International v. Metro Trading International. This sounds like it was an attempt to argue for a different rule, maybe applying the law of the contract instead of the lex situs.
Yes, exactly. This was a complex case involving large quantities of oil stored in tanks in Fujairah in the UAE. The company storing the oil, MTI, went insolvent. Various parties made claims to the oil, the original owners who put it there, the claimants, banks who had financed MTI, and other purchasers.
A multi-party dispute over ownership.
Precisely. The claimants argued that their proprietary rights should be determined by English law, because that was the proper law of their storage contracts with MTI. They argued this should apply, especially for determining non-contractual liabilities related to the oil. The opposing parties, however, argued that title had passed to them under the law of Fujairah, which was the lex situs of the oil.
So the core legal fight was, does the passing of property between the immediate parties to a contract, like the claimants and MTI, follow the proper law of their contract, or does it follow the lex situs of the goods if those two laws give different results?
And the court came down very firmly on the side of the lex situs. They applied Fujairah law. They rejected the argument that the proper law of the contract should govern the passing of title, even just between the original contracting parties.
Why did they reject that? It seems logical that your contract terms would govern your relationship with the other party.
The judge's reasoning was about consistency. He felt it would be highly anomalous if title passed between A and B according to the proper law of their contract. But if B then immediately sold the same goods to a third party, C, that second transfer, B to C, would undoubtedly be governed by the lex situs. You could end up with A still owning the goods under the contract law, while C simultaneously owns the same goods under the lex situs rule applied to the sale to them.
Right, that would be unworkable, multiple owners of the same thing.
Exactly. So while commentators like Cheshire North and Fawcett suggest the answer might sometimes be fact-sensitive, the Glencore case strongly indicates the English court's powerful preference for applying the lex situs to govern proprietary questions about tangible movables across the board, even between the original parties, to maintain consistency and avoid these kinds of anomalies.
Okay, that reinforces the strength of the lex situs rule. One more thing on tangibles. Renvoi. Does it apply here? We mentioned Iran v. Berend earlier in classification.
Right, and the source brings it up again here in the context of transfer. Remember, renvoi is the doctrine where if English law points to French law, does it mean just French domestic law or the whole of French law, including its conflict rules, which might point back to England or somewhere else?
Yes.
In the Islamic Republic of Iran v. Berend, which involved acquiring title to an ancient limestone fragment in Paris, the English court had to decide if French law governed. The question was, did French law mean domestic law only, or the whole law, including conflict rules?
And the decision for this tangible, movable.
The judge explicitly decided not to apply renvoi. The question of whether title was acquired under French law was decided by looking only at French domestic law. The judge specifically said applying renvoi is largely a question of policy.
So that's a key point. For tangible movables, the general rule, as shown in Iran v. Berend, is no renvoi when applying the lex situs rule. We just look at the domestic law of the situs.
Correct, and this is a crucial difference compared to immovable property, where, as we'll see, renvoi does generally apply. The source wraps up this section by quoting that commercial convenience may be said imperatively to demand that proprietary rights to movables shall generally be determined by the lex situs. That policy really is the bedrock here.
So the big picture for tangible movables. The lex situs rule dominates when determining if title has been transferred. This is powerfully shown by Camel v. Sewell and Winkworth. It applies even if the property moves later, driven by the need for commercial certainty. Exceptions are very limited, maybe extreme public policy, possibly but doubtfully, lack of good faith, and goods genuinely in transit. And importantly, no renvoi generally applies, as per Iran v. Berend. Just apply the domestic law of the situs.
Excellent summary. Now, moving from the physical world of tangible objects, we enter the more abstract realm of intangible movable property, things like debts, shares, intellectual property rights. These present their own unique challenges, primarily because, unlike a painting or a car, they don't actually have a physical location.
Right, that's the immediate hurdle. If the lex situs rule is so important, how on earth do you find the situs of something that doesn't physically exist anywhere?
Exactly. You can't just point to it.
Hmm.
So the law has to step in and ascribe a situs.
Mm.
It has to legally assign a location to these abstract rights for the purpose of applying conflict of laws rules.
Okay, so the law basically pretends it has a location. How does it decide where that fictional location is? The source gives some rules.
It does. It outlines the generally accepted rules for locating common types of intangibles.
Okay, what about intellectual property, like a patent or copyright? Where's the situs of that?
For IP rights, the situs is generally considered to be the country whose laws created the right, and where it can be effectively transferred under those laws. It's often also linked to where the rights holder is based. So a UK patent situs is the UK.
Makes sense. What about shares in a company? Where are they located?
The situs of shares is generally held to be the place where the company's share register is kept. More precisely, it's the place where the shares can be effectively dealt with as between the shareholder and the company.
Ah, so where transfers are officially recorded.
Yes. If a company, perhaps unusually, maintains share registers in multiple countries, the situs is typically considered the place where the shares can be most effectively dealt with, often the principal register. We saw the importance of the New York register in the Macmillan case, which we'll come back to.
Okay. And for a simple debt, like if someone owes me money, where's the situs of that debt?
The general rule for a simple debt is that its situs is where the debt is properly recoverable or enforceable against the debtor. Usually this means the place where the debtor resides.
Where the person who owes the money lives.
Typically, yes. If the debtor happens to reside in multiple places, the situs might be determined by where the contract expressly or implicitly requires payment to be made. The case Swiss Bank Corporation v. Boemisch Industrial Bank, although it dealt with garnishee orders, helps illustrate this principle of locating the debt where it's enforceable, often with the debtor.
Okay, so the law finds a way to give these abstract rights a legal home, a situs. Once we've done that, which country's law governs the assignment of that intangible right? Say, I sell my shares or assign a debt I'm owed to someone else.
Right, the transfer of the intangible. Well, the source points out that the old common law position here was a bit of a mess. There were inconsistent cases pointing in different directions. Levy Abdi suggested the law of the place where the assignment happened, the lex loci actus. República de Guatemala v. Núñez was ambiguous, suggesting either the domicile of the parties or the place of acting. It wasn't clear. Commentators like Cheshire, North, and Fawcett argued strongly that the better approach was to apply the proper law of the assignment contract itself, by analogy with how contract law was developing.
Okay, so common law was messy. Academics preferred the law of the assignment contract. But has this been clarified by legislation? Maybe those European regulations like ROMID?
Yes, absolutely. The Rome I regulation is now the key instrument here, specifically its Article 14. This article deals with the assignment of claims. Article 14, paragraph 1, governs the relationship between the assignor and the assignee.
So between the person selling the right and the person buying it.
Exactly. And Recital 38 in the regulation clarifies that this covers both the contractual aspects and the proprietary aspects of their relationship, i.e., whether the assignment effectively transferred the right between them.
Okay, and which law does Article 14.1 say applies to that assigner-assignee relationship?
It points directly to the law that governs the contract of assignment itself, determined according to the main choice of law rules within Rome. Article 3 allows parties to choose the law. Article 4 provides default rules if they don't choose.
And does this Rome I rule still apply in the UK after Brexit?
Yes. The source notes that the substance of the Rome I rules, including Article 14, continues to be applied in the UK through domestic legislation passed during the Brexit process. So, for determining the law governing an assignment contract, these rules are still what UK courts use.
Okay, so the law of the contract transferring the intangible right governs the relationship between the seller and buyer of that right, covering both contractual promises and the transfer itself between them. But what about a more fundamental question? Can the original right even be assigned in the first place? Some rights can't be transferred, right? Like maybe certain personal claims?
That's a crucial distinction. Whether the underlying claim or right is capable of being assigned at all is a separate question, and it's governed by Article 14, paragraph 2 of Rome I.
Okay, Article 14, what does that say?
It states that the law which governs the assigned claim itself the underlying right that's being transferred determines its assignability, and also governs the relationship between the assignee and the original debtor, conditions of enforcement, and discharge of the debt.
So if I'm trying to assign a debt owed under a French contract, it's French law that decides if that type of debt can be assigned.
Precisely. The law that created and governs the original right dictates whether it's transferable. The source uses Trentex Trading Corporation v. Credit Suisse as a key example. This involved assigning a right to sue, an English cause of action. The contract assigning this right was governed by Swiss law, but the court held that the question of whether the English cause of action was actually assignable was governed by English law, the law of the claim being assigned, not Swiss law, the law of the assignment contract. So Trentex confirms Article 14.2. You look to the law governing the underlying right to see if it can be assigned at all.
That's a very important distinction. Article 14.1 for the assignment contract between assignor-assignee, Article 14.2 for the assignability of the original claim itself, looking at the law governing that claim. What about assignments that don't come from a contract? Maybe something happens automatically by statute.
Good question. The source notes there's less certainty here. Rowan I primarily deals with contractual obligations. For non-contractual assignments, say of IP rights, commentators differ. Some, like Cheshire, North, and Fawcett, suggest applying the principles of Rome IR Article 14 by analogy.
Which might point towards the law of the transaction or maybe the assigner's law.
Potentially. Others, like the commentator Collier, argue for applying the lex situs of the intangible right itself once you've ascribed a situs to it. So a bit of ongoing debate for those non-contractual situations.
Okay. Another critical issue with intangibles, especially debts or funds, must be priorities. What if someone fraudulently assigns the same right to two different people? Who gets it?
Yes, priority disputes are a classic problem. The source highlights the important case of Kelly v. Selwyn. This involved assignments of a beneficial interest under an English trust fund, definitely an intangible right.
What happened?
Well, the beneficiary first assigned his interest to his wife in New York in 1891. Under New York law at the time, notice to the trustees wasn't needed to perfect the assignment. Then in 1894, the same beneficiary assigned the exact same interest to someone else, the plaintiff, in England. This second assignee immediately gave notice to the English trustees, as required by English law, to gain priority. The wife, the first assignee, didn't give notice until much later in 1903.
So, first assignment in NY, no notice needed there. Second assignment in England, prompt notice given. Who ranked first?
The English court held that the second assignee, the plaintiff who gave prompt notice according to English rules, had priority.
They applied English law to decide the priority. Why?
The reasoning in the original judgment wasn't perfectly clear. It could have been seen as lex fori, law of the court, or maybe lex situs, trust funds effectively located with English trustees. However, the source suggests the better interpretation, supported by Cheshire, North, and Fawcett, is that the law governing the trust fund itself, which was English law, was the determining factor for priorities.
Ah, so connecting it back to the underlying right again.
Exactly. And this seems consistent with the principle in Rome, or Article 14.2, which
Yeah.
states that the law governing the assigned claim also governs, well, the relationship with the debtor and conditions of enforcement, which arguably includes priority rules for making the claim effective against others. So Kelly v. Selwyn points towards the law of the underlying intangible governing priorities.
Okay, so the law governing the intangible itself seems key for assignability, trend text, and maybe priorities. Kelly v. Selwyn. Now, you mentioned a tension earlier between the Romi rule about the assignment contract, Article 14.1, and the idea of proprietary transfer, especially against third parties. Can we unpack that?
Yes, this is a subtle but important point the source raises. The potential conflict is this. Article 14.1 says the law governing the assignment contract determines the proprietary effect between the assignor and assignee. Let's say that's Swiss law, and the assignment is valid under Swiss law.
Okay.
But what if the lex situs of the intangible right being assigned, maybe it's a debt owed by a German company, so German situs, has a rule saying that for title to pass effectively, even between the original parties, some specific formality must be met, which wasn't met.
Ah, so the argument would be the affirmation is valid as a contract under Swiss law, per 14.1, but it might not have actually transferred the property right itself because it didn't comply with the lex situs, German law.
That's the potential argument, that maybe the lex situs should still govern the ultimate proprietary effect, particularly when considering third parties. However, the source is quick to point out that most leading commentators, like Dicey, Morrison, Collins, Cheshire, North, and Fawcett, and even the Dutch Supreme Court, tend to disagree with splitting it like this.
What do they argue?
They generally argue that the law chosen by Rome, or Article 14.1, to govern the assignment contract does indeed govern the proprietary effect, at least as between the assigner and assignee. They don't see a need to bring the lex situs back in at that stage.
But what about the case Raiffeisen Zentralbank Österreich AGV 5-Star General Trading LLC? Did that shed light on this? It involved an insurance policy assignment.
Yes, Raiffeisen is relevant here.
Yeah.
It involved the assignment of rights under a marine insurance policy. The policy itself was governed by English law, the assignment contract likely also governed by English law, but the insurer was French, so arguably the situs of the debt, the insurance claim, was France. Now, French law, the potential situs, had a strict rule requiring notice of the assignment to be given to the insurer via a specific official, a French bailiff, for it to be effective against the insurer. This hadn't been done. English law, governing the policy in the assignment contract, just required written notice, which had been given. The question was, could the assignee sue the French insurer?
So which law decided if the assignment was effective against the debtor, the insurer? French situs law or English proper law?
The English court applied Article 12 of the Old Rome Convention, which is the direct predecessor of Rome. The Article 14.2. This provision points to the law governing the assigned claim, i.e. the insurance policy itself.
Which was English law.
Right. And since notice under English law was sufficient, the court held the assignee could recover from the French insurer. They effectively prioritized the law of the underlying claim over the law of the situs of the debtor when determining effectiveness against that debtor.
So Raiffeisen seems to bolster the importance of Article 14.2, the law of the assigned claim for determining effectiveness against the original debtor, maybe pushing the lex situs further into the background.
It certainly points that way in the context of effectiveness against the debtor. However, the source does add a note of caution. Commentators like Clarkson and Hill still see an obvious attraction in applying the lex situs to purely proprietary questions, especially concerning who has title against the whole world, not just against the debtor. They cite Macmillan v. Bishopsgate, the shares case, where the lex situs was decisively applied to determine title priority between competing claimants.
Ah, okay.
So the implication is, while Romite Article 14 is central, especially 14.1 for the assignee relationship and 14.2 for assignability and debtor relations,
Yeah.
the debate about whether the lex situs might still have a residual role in determining the ultimate proprietary effect against third parties hasn't entirely vanished. It's complex.
Definitely sounds complex. Okay, so for voluntary assignments of intangibles, Rome Article 14 is the star. 14.1 uses the proper law of the assignment contract for the assigner-assignee relationship. 14.2 uses the proper law of the underlying claim for assignability and debtor relations, like in Trentex and Raiffeisen, and maybe priorities, Kelly v. Selwyn. But there's still a bit of a question mark over the exact role of the lex situs for the ultimate proprietary effect against the world.
That's a very good handle in a tricky area. Now, just briefly, the source also covers involuntary assignments, focusing specifically on garnishee orders.
Right, these are court orders where if A owes money to B and B owes money to C, the court can order A to pay C directly, bypassing B.
Essentially, yes. A is the garnishee, B is the judgment debtor, C is the judgment creditor. It's a way for C to enforce their judgment against B by intercepting money owed to B.
And the conflict of laws issue arises when A, B, and C are in different countries, or the debt itself has a foreign connection.
Exactly. An English court can issue a garnishee order if the garnishee, A, the one holding the funds, is within English jurisdiction or submits to it. The court also needs the debt to be legally enforceable in England. The main problem, the conflict issue, is the risk of the garnishee paying twice.
Oh, so?
Well, the garnishee, A, pays the creditor, C, under the English court order, but what if the original debtor then sues the garnishee, A, in a foreign court for the same debt, and that foreign court refuses to recognize the English garnishee order? A could be forced to pay the debt all over again, this time to B.
Ouch. That seems like a very real risk for the garnishee, often an innocent bank or something.
It absolutely is. The source mentions Swiss Bank Corporation v. Boemisch Industrial Bank. Here, an English creditor wanted to garnish funds held by a Czech bank, the debtor B, in an account at its London branch, the garnishee A. The argument against making the order was precisely this risk the London bank might be forced to pay again in Czechoslovakia.
And what did the court decide in that case?
The court granted the order. Their reasoning was that since the debt situs was considered to be in London, where the account was held, and the Czech bank had submitted to the English court's jurisdiction, the risk of the London bank being forced to pay again was only theoretical.
Okay, so if the risk is just theoretical, the order might be granted. But the source also mentions Deutsche Schachtbau v. Shell International Petroleum Co. Ltd. Did that change things?
It clarified the principle. Deutsche Schachtbau established that an English court may indeed refuse to grant a garnish order if there's a real risk, not just theoretical, that the garnishee will be compelled by a foreign court to pay the debt a second time. The source notes the court expressing concern about foreign courts potentially indulging in judicial extortion by ignoring valid English orders.
So the insight for involuntary assignments like garnishee orders is an English court has power over a garnishee here, but it will consider the practical risk of double jeopardy. If there's a real chance the garnishee will have to pay twice abroad, the court might refuse the order to protect them.
Precisely. It's a balancing act. So, summing up intangibles. First, ascribe a situs, where registers for shares, where debtor is for debts, etc. For voluntary assignments, Rome Section Article 14 is key. A proper law of assignment for assignee, proper law of claim for assignability debtor relations, with lingering questions about lex situs for proprietary effect. For involuntary garnishee orders, the court weighs the creditor's right against the garnishee's real risk of paying twice.
Okay, that covers the general categories of movables, tangible, and intangible. Now, the source zooms in on two specific types of property that have their own particular rules: negotiable instruments and shares.
Yes, these are common in international commerce and finance, so they get special attention. Let's start with negotiable instruments, things like bills of exchange, promissory notes, checks.
Right. How are conflict issues handled for these? Is it lex situs, proper law?
Actually, for many key issues, the choice of law rules are laid down in a specific statute. The Bills of Exchange Act, 1982, particularly Section 72.
Ah, okay. So the statute gives us the answers. What does Section 72 say?
It breaks it down. For the formal validity of the instrument itself, like, does the bill meet the basic requirements to be a bill of exchange that's determined by the law of the place where it was issued?
Okay. Place of issue for initial form. What about things that happen later, like someone endorsing it on the back to transfer it?
For the formal validity of these supervening contracts on the bill, like an acceptance or endorsement, the rule is different. It's governed by the law of the place where that specific contract, the acceptance or endorsement, was made. That's the lex loci actus.
Lex loci actus, law of the place of acting.
Okay.
What about interpreting these different contracts on the bill?
Same rule again. The interpretation of the drawing of the bill or an endorsement or an acceptance is determined by the law of the place where that specific contract was made, the lex loci actus.
So, for many of the practical issues that arise with negotiable instruments, the form and meaning of endorsements, acceptances, etc., Section 72 points us firmly towards the lex loci actus, the law of the place where that particular action happened.
That's the general thrust of Section 72, yes. The source does note, interestingly, that some early cases decided after the Act's predecessor came into force didn't always seem to pay close attention to the statute. Cases like Alcock v. Smith and Imbiricos v. Anglo-Austrian Bank did apply the lex loci actus, but in Imbiricos, it's possible the situs of the bill happened to be in the same place, which might confuse the reasoning slightly.
Okay, but was the position clarified later?
Yes. The source points to Cochran et C. v. Kestenbaum. In that case, the Court of Appeal held quite clearly that the statutory provision, the forerunner of S.72, had settled the choice of law rule for these matters. It confirmed the rule was indeed the lex loci actus, the law of the place where the relevant contract on the bill was made.
Right, so the takeaway for negotiable instruments is check the Bills of Exchange Act 1982, Section 72. It generally points you to the lex loci actus for key issues like the formal validity and interpretation of contracts made on the instrument, a principle solidified by Cochran.
Exactly. Now, let's switch to shares. We touched on these earlier as intangibles. We know their situs is generally where the register is kept. What's the core rule for conflict issues involving shares, particularly about who owns them?
Is it the lex situs again?
Yes. The fundamental rule is questions relating to title to shares are governed by the lex situs of the shares.
Title to shares follows the law of the place where they can be effectively dealt with between the shareholder and the company, usually the place of the main register.
Precisely. And the source brings back the case of Macmillan Inc. v. de Bishopsgate Investment Trust, PPAM-folk, specifically to hammer this point home for shares. It's really the leading authority.
Remind us of the key facts in Macmillan relating to the shares.
Sure. The plaintiff, P, owns shares in a company incorporated in New York with its principal share register also in New York. So the situs was New York. These shares got caught up in the complex dealings of the Maxwell Group and were used as collateral for loans from various banks, D2. Some of the transactions involving the share certificates happened in London, some electronically via systems in New York. Eventually, the shares ended up registered in the names of the banks on the New York register.
And the legal battle was between the original owner, P, claiming they still had beneficial title, and the banks, D2, claiming they were bona fide purchasers for value without notice. Priority of title dispute.
Exactly. And the crucial first step for the Court of Appeal was to classify the issue. They decided it was fundamentally a proprietary question who had the better title to the shares, rather than, say, a claim about unjust enrichment, restitution.
Okay, it's about property rights in the shares. Which law governed that proprietary question?
The Court of Appeal held decisively that the question of priority of title to the shares was governed by the lex situs of the shares.
Which was New York law because the register was there.
Correct. So the court applied New York law to the dispute. Under New York law, the banks were found to qualify as bona fide purchasers who took title free from the plaintiff's earlier equitable interest. Therefore, P's claim failed. Title had validly passed to the banks, according to the lex situs.
So, Macmillan is a very clear example. Even though some related activity like handling certificates might have happened in London, the ultimate question of who had good title to the shares themselves was determined solely by the law of the shares situs New York in that case. It really confirms the dominance of lex situs for title issues with shares.
It's a cornerstone case for that principle. And the source also uses Macmillan to reiterate the distinction we mentioned earlier between the shares themselves, the intangible right, and the share certificates, the physical document. Macmillan confirmed that while the physical location of the certificate might be relevant for certain things, like who has the right to possess the certificate, it is the situs of the shares, determined by the register where they can be dealt with, that governs the crucial question of title to the shares themselves.
Got it. So the key insight for these specific property types. For negotiable instruments, look to the Bills of Exchange Act .72, often leading to the lex loci actus. Coquelin. For shares, questions of title are firmly governed by the lex situs, meaning the law of the place where they are registered and can be dealt with. Macmillan.
Exactly. Now, having covered movables, both tangible and intangible, and specific types like instruments and shares, let's turn our attention to the most grounded form of property. Immovables, land and buildings.
Right. Things that definitely don't move. You'd think this might be simpler, but conflict of laws seems to find complexity everywhere. What are the issues with land located outside England?
Well, there are two main layers of rules here. First, there's a question of jurisdiction. Can an English court even entertain a dispute about foreign land? And second, if it can take jurisdiction, which country's law does it apply to resolve the dispute, the choice of law question?
Okay, let's start with jurisdiction. Can I sue someone in an English court about the ownership of my apartment in Spain, for example? The source mentions the Mozambique rule.
Yes, the Mozambique rule is the starting point, and it's a restrictive one. It comes from the old House of Lords case, British South Africa v. Company of Mozambique. It's a long-established common law rule stating that English courts generally lack jurisdiction to hear cases where the central issue is determining title to, or the right to possession of, immovable property situated outside England and Wales.
So if the main fight is about who owns that Spanish apartment or who has the right to live there, an English court will usually say, nope, can't hear this case, go to Spain.
Broadly, yes. The source calls it a self-denying rule. The English courts restrain themselves from getting involved in disputes directly about the title or possession of foreign land.
Has this rule been applied broadly?
It has. It was even extended, controversially, to cover claims relating to foreign intellectual property rights in Tyburn Productions v. Conan Doyle. And historically, it applied to torts, like trespass, affecting foreign land, as seen in Hesperides Hotels v. Aegean Turkish Holidays. However, that specific extension to torts was significantly cut back by statute.
Oh, how so?
Section 30 of the Civil Jurisdiction and Judgments Act 1982 now generally allows English courts to take jurisdiction over claims for trespass or other torts affecting foreign land, unless the proceedings are principally concerned with the question of title to or the right to possession of that land.
Okay, so maybe I can sue someone in England if they damage my Spanish apartment, as long as the main point isn't arguing about who actually owns it.
That's roughly the line the statute tries to draw for tort claims. But for claims principally about title or possession, the basic Mozambique rule generally still holds. No jurisdiction. However, like many rules, it has exceptions.
Ah, okay. Exceptions to the Mozambique rule, what are they?
The source highlights two main ones. The first is quite specific. It applies when an English court is already properly administering a trust, or the estate of a deceased person, a will, which happens to include foreign land. If a question about title or possession of that foreign land arises incidentally as part of that larger administration process, the English court might deal with it.
So it's not the main focus, just a side issue in a case the court is already handling.
Exactly. The second exception is much more significant and frequently encountered. It's the exception for actions in personam.
Actions against the person. What does that mean here?
It means that even though an English court won't directly rule on the title to foreign land, it can exercise jurisdiction over a defendant who is properly before the court, t.g. they live here or are served here, to compel that defendant to fulfill a personal obligation they have in relation to that foreign land.
So the court isn't making a judgment about the land itself, but ordering the person in front of them to do something connected to it. Like, you signed a contract to sell that Spanish apartment, now honor it.
Precisely. The court acts on the person, leveraging its authority over them. If the defendant has, say, contracted to sell foreign land or holds it on trust for the claimant, the English court can order them to perform their obligation, for example, execute a conveyance. If the defendant refuses, they are in contempt of the English court, regardless of what the foreign law says about the underlying title at that point.
Okay, that's a crucial way around the main rule. Are there conditions for this in personam exception to apply? Can the court just order anything?
No, there are strict conditions. The source lists 3 key requirements that must all be met. First, the defendant must be subject to the English court's jurisdiction. They must be here or properly served abroad under the rules.
Okay, gotta have the defendant.
Second, the claimant's case, the personal obligation they seek to enforce, must arise from one of 3 specific types of situations. Either a contract between the parties concerning the land, or some fraudulent or unconscionable conduct by the defendant relating to the land, or an existing equitable or fiduciary relationship between the parties connected to the land, like a trust.
So the obligation must stem from contract, fraud and conscionability, or a trust fiduciary duty involving the land. What's the third condition?
This is a really important one, showing respect for the foreign legal system. The specific act that the English court is considering ordering the defendant to perform must not be illegal or impossible according to the law of the country where the land is actually located.
So the English court won't order someone to sign a deed transferring Spanish land if Spanish law absolutely forbids that type of transfer or makes it impossible for that person to do it.
Exactly. The English order must be capable of being lawfully carried out in the foreign country. It shows deference to the ultimate authority of the lex situs over the land itself.
Okay, so the jurisdiction summary for foreign land. The Mozambique rule generally bars English courts from deciding title or possession disputes directly. But there are exceptions, crucially the in personam exception, where the court can order a defendant, who is subject to its jurisdiction, to fulfill a personal obligation relating to the land, provided that obligation stems from contract, fraud, or trust fiduciary duty, and the order itself isn't impossible or illegal under the lex situs.
That's the jurisdictional picture. Now, let's say an English court does have jurisdiction, perhaps under the in personam exception, or maybe the dispute isn't mainly about title, like that tort example. Which country's law does it then apply to decide the issues concerning the foreign immovable property? This is the choice of law question.
Okay, what's the rule here? Is it complicated?
Actually, for choice of law regarding immovables, the rule is remarkably simple and incredibly strong. There is almost total dominance of the lex situs.
The law of the place where the land is located governs pretty much everything about it.
For inter vivos matters things done between living people, like sales, gifts, mortgages, yes, comprehensively. The source quotes Lord Langdale back in Nelson v. Bridport, saying that all the incidents to real estate, the right of alienating or limiting it, the succession to it, though succession has nuances, we'll see, depend entirely on the law of the country where the estate is situated.
Why such complete dominance for the lex situs here? It seems even stronger than for tangible movables.
But justification, as Cheshire and North put it, quoted in the source, is fundamental. Only the law of the situs can control the way in which land is transferred. Land is physically part of the territory of the situs country. Its legal system is the only one that can ultimately enforce rights and changes relating to that land. Any other country's law trying to dictate what happens to land elsewhere would simply be ineffective.
Right, an English court order saying French land belongs to X is meaningless if the French system doesn't recognize it.
Precisely. So the law of the situs must govern. Are there any exceptions to this lex situs dominance for inter vivos transfers of immovables?
The source seems pretty clear on this. It mentions exceptions for succession issues, but says there are none for inter vivos transfers. It seems absolute in that context.
That's right. For transfers between living people, the lex situs reigns supreme. Now remember our discussion about renvoi. For tangible movables, the Iran v. Barrand case suggested no renvoi, just apply the domestic law of the situs. Is it the same for immovables?
Good question. Does renvoi apply when we look to the lex situs for lands?
Yes, it does. And this is an absolutely crucial distinction to grasp. When an English court's conflict rule points to the law of the situs for an immovable property issue, this is interpreted as meaning the entire legal system of the situs, including its own conflict of laws rules.
So the English court tries to decide the case exactly as a court in the situs country would, potentially applying the situs country's rules about whether to apply its own domestic law, or maybe English law, or even a third country's law.
Exactly that. The English court effectively sits in the chair of the foreign judge and asks what they would do. This is a major area where the doctrine of renvoi is applied in English conflict of laws. The source cites Re Ross and Re Duke of Wellington as authority for applying renvoi to immovables.
Okay, that's a really key difference. Tangible movables, generally no renvoi. Immovables, renvoi applies. Got it. How does this dominant lex situs rule, including renvoi, play out for specific aspects of a land transfer, like capacity? Can someone sell foreign land if their own law says they can, but the lex situs says they can't?
No, capacity is governed solely by the lex situs. The source uses Bank of Africa v. Cohen to illustrate this point vividly.
Remind me of that one.
It involved a married woman domiciled in England, where she had capacity to contract. She entered into an agreement in England to mortgage her land, which was located in South Africa, to secure her husband's debts. However, under South African law at the time, the lex situs, married women lacked the capacity to enter into such surety agreements.
So even though she had capacity by her personal law, English domicile, and made the agreement in England, her lack of capacity under the law of South Africa, where the land was, meant the mortgage agreement was invalid.
Correct. The English court held she couldn't validly create the mortgage over the South African land because the lex situs dictated she lacked the capacity to do so. Buckley LJ explicitly cited Dicey's rule that capacity regarding immovables is governed by the lex situs.
Okay. Capacity follows the lex situs. What about the formalities? Like, does the deed need a seal or witnesses according to English law or the lex situs?
Formal validity is also governed only by the lex situs. The source gives the example of Adams v. Clutterbuck. This involved a conveyance of shooting rights, considered an interest in land and incorporeal hereditament, located in Scotland. The deal was between two Englishmen. The conveyance document wasn't made under seal, which was a requirement for transferring such rights under English domestic law at the time. However, Scots law, the lex situs, did not require a seal for this type of transaction.
And the court held the conveyance was valid.
Yes, because it complied with the formal requirements of Scots law, the lex situs. The English requirement for a seal was irrelevant because the property right was Scottish.
So, formalities are dictated solely by the lex situs and the substance. The essential validity of the transfer: can you create certain types of interests in land if the lex situs doesn't allow them?
Essential validity is also governed only by the lex situs. The source gives the example of the English rule against perpetuities. If you try to create an interest in English land that violates this English rule, the disposition is void, regrassi. It doesn't matter what the law of the party's domicile might say. English law, as the lex situs, determines what kinds of legal estates and interests can validly be created in English land and what limitations apply.
Okay, the picture for immovables is very clear then. Jurisdiction, generally excluded by Mozambique rule for title possession claims, but with exceptions, notably the in personam action based on contract fraud trust, provided the order isn't illegal by the lex situs. Choice of law. Overwhelming, near absolute dominance of the lex situs for all aspects of inter vivos, transfers capacity, Bank of Africa, formalities, Adams v. Clutterbuck, essential validity, regrassi, and crucially, renvoi applies when determining the law of the situs for immovables. Re Ross, re Duke of Wellington.
That's a perfect encapsulation. Now, for our final section, let's shift focus to a specific context where property rights often interact with foreign elements: matrimonial property. How does marriage affect the property rights of spouses, especially when they might have connections to different countries?
Right, because marriage itself can fundamentally alter property rights. Different countries have vastly different systems. You mentioned community of property systems versus England's general approach of separate property. How does conflict of laws sort this out?
The source breaks it down based on whether the couple made a specific agreement about their property before or at the time of marriage. So two main scenarios.
Okay, scenario one. A couple gets married without making any kind of marriage contract or settlement dealing with their property. They just get married. What law then governs how the marriage affects their property ownership?
Here, the law traditionally distinguishes between movable and immovable property. For movable property, the effect of the marriage on their rights, for example, does community property arise, is generally governed by the law of the matrimonial domicile.
Matrimonial domicile. How is that defined? Is it just where they happen to live when they get married? Or where they intend to live?
Traditionally, and as applied in the older key cases, the matrimonial domicile was considered to be the domicile of the husband at the precise time of the marriage.
The husband's domicile at marriage seems a bit dated.
It does reflect the legal norms of the time. The force uses Ray Egerton's will trusts to illustrate this. It involved an English soldier, domiciled in England, marrying a French woman, domiciled in France. They got married in England. They apparently intended to move to France as soon as possible to set up home there, but in reality it took them 2 years to actually move.
Okay. And later, after the husband died, the wife claimed she should have rights based on French community property law because France was their intended home.
Yes, that was her argument, but the court rejected it. It held that the matrimonial domicile was determined by the husband's actual domicile at the moment of marriage, which was England. Therefore, English law, separate property, applied to their movable assets, not French community property law.
So the husband's domicile at the wedding trumped their future intentions, even if quite firm.
In Egerton, yes. The judge did concede that in truly exceptional circumstances, perhaps if the couple moved to their intended new domicile immediately after the wedding and had very little property at the time of marriage, then maybe, just maybe, The intended domicile could be considered the matrimonial domicile, but it was presented as a very high bar.
So the default strong starting point for matrimonial domicile determining rights in movables without a contract is the husband's domicile at the time of marriage.
That's the traditional position, yes, reinforced by other cases like the South African case, Estate Frankel v. the Master, which applied the law of the German domicile at marriage rather than the intended and later actual South African domicile. Of course, the source rightly notes that now wives can have their own independent domicile. The automatic application of the husband's domicile might be more open to challenge today, but Egerton represents the classic approach.
Okay. Now, what happens if this couple, governed initially by the law of their matrimonial domicile, say English law, later changes their domicile? They move permanently to France. Does the law governing their movable property then change to French law?
This brings us to a famous theoretical debate. The doctrine of mutability versus immutability regarding the effect of a change of domicile on matrimonial property rights in movables.
Mutability versus immutability. What's the difference?
Mutability means the applicable law changes with the domicile. So if the couple moves from England to France, French law would govern the property they acquire after moving to France. This view has found favor in places like the USA.
Okay, so the legal regime travels with the couple. What's immutability?
Immutability means the property regime established by the law of the matrimonial domicile at the time of marriage remains fixed and continues to apply to all their movable property, even property acquired after they change their domicile. So if they started under English law principles would continue to apply even after they moved to France.
So fixed at the wedding day versus changing with the couple's home. Which view does English law take?
Well, it's not perfectly settled, but the weight of opinion leans towards immutability, or at least against automatic mutability. The source discusses the old Scottish case Lashley v. Hogg, which is sometimes cited as supporting mutability because a change of domicile did affect rights in that case. However,
Yes.
the source points out that the House of Lords, when they later considered Lashley v. Hogg in the very important case of D. Nichols v. Curlier, the Café Royal case, concluded that Lashley wasn't really clear authority for the general principle of mutability in the matrimonial property context.
So the current thinking leans away from automatic mutability.
Yes, Cheshire North and Fawcett, cited in the source, argue that much more decisive authority than Lashley v. Hogg would be needed to establish that proprietary relations automatically change just because a couple changes domicile. They suggest a possible key is distinguishing between rights that are merely inchoate potential and rights that have already vested under the previous domicile's law.
Meaning rights already acquired and solidified under the old law might be protected.
That seems to be the idea. Vested rights are likely unaffected by a change of domicile. The source notes some Canadian cases, Pink v. Perlenico, Rahong Wanlei, support this kind of a vested rights approach. It also adds the practical point that now both spouses can have independent domiciles. Presumably, both would need to change their domicile together for there to be any potential argument for a change in the applicable law, adding another layer of complexity. So the general leaning seems towards immutability, protecting vested rights, absent clear authority otherwise.
Okay, so for movables without a contract, the matrimonial domicile, husbands at marriage traditionally, sets the regime, and that regime likely remains immutable, especially regarding vested rights, even if they change domicile later. What about their immovable property? Does a change of domicile affect the law governing their house in Spain?
No. This is absolutely clear and consistent with what we discussed earlier about immovables generally. Rights in immovable property acquired by the spouses are always governed by the lex situs of that property, regardless of the spouse's matrimonial domicile or any subsequent changes to it.
So the mutability-immutability debate is irrelevant for land.
Completely irrelevant. The source cites Welch v. Tennant for this. It gives the striking example. An English domiciled couple buys a holiday home in Spain, a community property country. Even though their matrimonial domicile remains English, separate property, Spanish law, the lex situs applies to that house. It likely becomes community property under Spanish law, perhaps much to the surprise of the English husband who bought it.
That's a critical point. Lex situs trumps domicile changes completely for immovables in marriage. Okay, that covers the scenario without a marriage contract. What about scenario 2, where the couple does have a prenuptial contract or settlement dealing with their property?
Right, if they've made an agreement beforehand. First point, do the Romae rules apply to these contracts?
You mentioned earlier Roma excludes matrimonial property rights.
Correct. So these marriage contracts are governed by English common law, choice of law rules, not the regulation. The crucial consequence of having a valid contract is this. It determines the spouse's proprietary rights according to its terms, and the whole debate about matrimonial domicile and immutability becomes irrelevant. The contract governs.
And can the contract cover both movable and immovable property?
Yes, if the contract is intended to cover both, its terms will generally apply to both, overriding the default rules, matrimonial domicile for movables, lex situs for immovables, that would have applied without a contract.
Does it matter if it's a formal written contract or one that's just implied by the law of the place they married?
The source says no distinction is drawn. An implied contract arising by operation of law is treated the same as an express written one.
Mm.
And the absolute central case here is D. Nichols v. Curlier.
The Café Royal case again. Let's recap the facts.
French couple, both domiciled in France, get married in France without making an express written contract about their property. Under French law at the time, this meant a system of community property was automatically implied by law as governing their assets.
Okay, so they had an implied contract for community property under French law.
Yes. They then moved to England, acquired an English domicile, became very successful running the Café Royal Hotel, and accumulated substantial wealth, both movable and immovable, in England. The husband died, leaving a will that disposed of all the property as if it were solely his, ignoring the wife's potential half-share under the French community system.
So the big question was, did their change of domicile from France to England get rid of the property regime established by that implied French contract?
Exactly. And the House of Lords tackled the movable property first. They held, unequivocally, that the implied French contract was a valid compact between the spouses, and it was not destroyed or nullified simply by their later change of domicile to England.
So the contract survived the move.
Yes. Lord Macnaghten famously asked, rhetorically, how a valid contract could be nullified or blotted out merely by a change of domicile. The conclusion was the wife was entitled to her half share of the movable property accumulated during the marriage, according to the French community property law implied by their original contract.
That's a huge statement about the power of the initial matrimonial property regime established by contract, even implied. What about the immovable property they acquired in England? Did the French implied contract govern that too, overriding the usual lex situs rule?
This was decided in a subsequent hearing, read de Nichols by Kipiewicz J. He held that, yes, the implied French contract did also extend to govern the immovable property acquired in England. The source notes this part of the decision has faced some academic criticism, perhaps because it seems like a very strong challenge to the usual dominance of the lex situs for immovables. However, the source also points out there is other case support, like the South African case UoL v. Carlian, for the principle that the law governing the marriage contract can indeed apply to immovables covered by its terms, effectively displacing the default lex situs rule.
So the massive insight from de Nichols v. Curlier is a valid marriage contract, whether express or implied by the law of the matrimonial domicile, creates a property regime that generally endures despite subsequent changes of domicile, and its terms can govern both movable and immovable property acquired later, overriding the default conflict rules that apply in the absence of a contract.
That is absolutely the crucial takeaway from de Nichols. It shows the power of contract in this area. Now, just a few quick points on the validity of these marriage contracts themselves. What about capacity? Which law decides if the parties were old enough or mentally capable enough to enter the contract? The law here is a bit uncertain, according to the source. There are arguments for applying the proper law of the marriage contract itself, by analogy with commercial contracts, which the source suggests is probably the better view. But there are also arguments for applying the lex domicilii of the parties at the time, by analogy with capacity to marry. Some older cases seem to superficially support the lex domicilii view, but the source finds them unconvincing.
So capacity is a bit murky, but leaning towards the proper law of the contract. What about formal validity? Does the contract need to be in writing or witnessed according to which law?
Here, the rule is quite flexible and favorable to upholding the contract. A marriage contract will be considered formally valid if it complies with the requirements of either its proper law or the lex loci contractus, the law of the place where the contract was physically made. Compliance with either one is sufficient.
Ah, okay. That's helpful. Cases supporting this.
Van Groten v. Digby and Geprat v. Young are cited. This is notably more relaxed than the strict lex situs rule for the formal validity of conveyances of land itself.
Makes sense. And finally, essential validity. The legality and substance of the contract's terms.
Essential validity is governed by the proper law of the marriage contract. Parties are free to expressly choose the law that governs their contract. If they don't make an express choice, the proper law will be the law of the country with which the contract has its closest and most real connection. There's a strong presumption here that this will be the law of the matrimonial domicile at the time the contract was made.
So often defaulting back to the matrimonial domicile if no other law is chosen.
Yes, Reed Fitzgerald supports this presumption. And importantly, once this proper law is established, whether by choice or by connection, often the matrimonial domicile, it continues to govern the essential validity of the contract, even if the parties later change their domicile.
Okay. And if the contract actually creates a trust.
The source notes that if a marriage settlement creates a trust, its essential validity would likely be governed by the specific rules in the Recognition of Trusts Act, 1987.
Got it. What about civil partnerships? Are the rules the same?
The Civil Partnership Act 2004 itself is silent on the choice of law rules for property. However, the source suggests it's highly likely that the same common law rules developed for married persons would be applied by analogy to civil partners.
Okay, makes sense. Lastly, you mentioned those EU regulations earlier, 21.6, 1103, and 1104. Just to be clear, they don't apply in the UK.
Correct. The source emphasizes the UK opted out. These regulations apply only within the 19 participating EU member states, and only to marriages or registered partnerships entered into from January 29, 2019. They don't represent current UK law.
But they show a different approach.
Yes, they're worth knowing about as a contrast. Their aim was to create uniform rules across participating states for jurisdiction, applicable law, and recognition enforcement concerning matrimonial property regimes and registered partnerships.
What are some key features?
They have a universal scope for applicable law, Article 21, meaning the rules can point to the law of any country, even a non-EU one. They apply to all property, movable and immovable, regardless of status. They set out detailed rules on which countries' courts have jurisdiction, linked to death, divorce, habitual residence, etc. They allow spouses' partners to choose the applicable law, within limits, Article 22, and provide default rules if no choice is made, Article 26. And judgments given under the regulations in one participating state are generally recognized and enforceable in the others.
So, a much more harmonized, codified system compared to the UK's common law rules derived from cases.
Exactly. It's a different model, aiming for greater integration and uniformity within the participating EU states, but it's not the system you'd apply in an English court today.
Right. So, wrapping up matrimonial property, two paths. Path one, no contract. Movables governed by matrimonial domicile, traditionally husbands at marriage, Riagatin, subject to the immutability debate on change of domicile, Nichols' analysis of Lashley. Immovables always governed by lex situs, Welsh v. Tennant. Path two, valid contract exists, governed by common law, not Romor. Contrast proper law governs rights in both movables and immovables covered. Capacity rules uncertain, proper law versus domicile. Formal validity needs compliance with either proper law or lex loci contractus, Van Groten. Essential validity governed by proper law, presumed matrimonial domicile of no choice, Reed Fitzgerald. EU regs are a different system, not applicable in UK.
That perfectly captures the essence of the matrimonial property rules. And that brings our deep dive into this whole complex area of conflict of laws regarding property to a close. We've certainly covered a lot of ground.
We really have. We started right back at the beginning with the absolute necessity of classifying property for conflict purposes, using movable, immovable, tangible, intangible, and the critical role of the lex situs in making that classification, which is different from English domestic law, as cases like Freak v. Lord Carberry and Berchtold showed us.
Then we moved into the transfer of tangible movables, establishing the dominance of the lex situs for determining if title passed, powerfully illustrated by Camel v. Sewell and Winkworth v. Christie Manson and Woods. We saw how this rule generally holds even if the goods move, driven by commercial certainty, with very limited exceptions, and usually no renvoi, Iran v. Berendt.
Then we navigated the tricky waters of intangible movables, ascribing a situs, applying Rome Article 14.14.1, using the assignment's proper law for the parties' relationship, 14.2, using the underlying claims law for assignability, Trentex, and maybe priorities, Kelly v. Selwyn, while acknowledging the ongoing debate about the lex situs and ultimate proprietary effect, plus the specific issue of garnish orders and the risk of paying twice, Deutsche Schachbau.
We drill down into specific types. Negotiable instruments, guided by the Bills of Exchange Act, .72, often pointing to the Lex Loci Actus, Coquelin, and shares, where title is decisively governed by the Lex Situs, meaning where they're registered and dealt with, Macmillan.
And then we tackled immovables outside England. The jurisdictional hurdle of the Mozambique rule, generally barring title possession claims, but with the crucial impersonam exception based on contract, fraud, or trust, provided the order is possible under the lex situs. And for choice of law, the almost total dominance of the lex situs for inter vivos transfers covering capacity, formality, and essential validity, remembering that run boy applies here, re Ross.
And we finish with matrimonial property, distinguishing between having a contract or not. Without a contract, it's matrimonial domicile for movables, with the mutability debate, and lexitis for immovables. With a valid contract, its proper law governs both, overriding default rules, as shown definitively in Dillos v. Curlier.
It's clear that while these rules are intricate, they form a necessary system. They aim to bring certainty and avoid conflicting judgments by logically pointing towards the most appropriate legal system, whether that's based on where the property is, where a transaction happened, or where the parties are domiciled or connected by contract.
Absolutely. And you can see the policy choices behind the rules, the constant tension between achieving certainty, particularly in commerce, versus achieving fairness for an individual party, or balancing the sovereignty of the lex situs with obligations created elsewhere. It requires careful analysis of the property type and the specific legal question being asked: jurisdiction, classification, choice of law.
Well, we sincerely hope this detailed exploration of the material made available by the University of London has helped clarify these crucial and sometimes challenging points for you, our listener. And remember, this deep dive is purely for educational purposes.
And it was brought to you by Sinorbit Academy, Sri Lanka.
For those of you using this, perhaps preparing for an exam, we really hope drilling down into the cases, the rules, the reasoning has helped build your understanding and confidence. You've got this. Go crush that exam. Wishing you the very, very best of luck.
Indeed. All the best with your studies and preparations.
Thank you for joining us on the deep dive. We'll be back with another exploration soon.